So hi, I'm Rebecca Secord. I am an estate planning and real estate attorney in San Diego, and I work with people all over California in protecting their families. Whether you have chosen family, whether you have blood family, whether you're married, whether you're single, whether you have kids, whether you don't have kids, whether you're queer or you're not queer, that's who we work with. Today's workshop is specifically geared toward the LGBTQ community and estate planning because our community has some special needs that require special planning. And a lot of times people think estate planning is not for me for whatever reason. Today, we're going to talk about why that's not the case and why estate planning is for you, especially if you identify as LGBTQ and everything else under the rainbow. So, a little bit of a disclaimer because I'm a lawyer and we do lawyer stuff over here. This is not going to be legal advice. The next 45 minutes or so is purely for informational purposes only. I'll tell some stories. There will be opportunity for questions and answers at the end. But at the end of the day, specific questions, I can't really give you specific answers because it depends. Whatever your question is, it's going to depend on a whole lot of other things because I'm very curious and I ask a whole lot more questions because whatever it is that you're asking probably requires a little bit more of attention. Ask questions. This is an informational, it's a learning opportunity to learn about estate planning and how that can help you do the things that you need and want to do. Something else to consider, the information that's contained in this video when you're watching it may not be accurate. The laws change slowly, albeit, but it might not be accurate. So that's the other reason why we don't provide advice is because the information that we're providing today might not be accurate 5 or 10 years down the road. So, who am I? I'm Becca. I'm a queer estate planning attorney and real estate attorney, like I mentioned at the beginning. I'm from San Diego. Well, I live in San Diego, work in San Diego, and I work and help clients all over the state of California with their estate planning and their real estate needs. I grew up in Chicago, went to law school in Boston, and lived in the DC metro area for about 10 years. I play softball. Shocker, shocker. I have a little human who's not so little anymore, and we have 2 crazy ginger cats who are just wild. I've been an attorney for about almost 15 years now, which is kind of crazy, but I've been doing this for as long as I've been an adulting. And whether you're here to learn more about estate planning, whether you're here to support what we're doing here, it's great because you're making an effort to learn something that a lot of people don't take the time and effort to learn. So what is estate planning? I'll tell you what it's not. It's not just for rich people. It's not just for old people. It's not just for people who have kids or just for people who have real estate. While estate planning does serve all of those people, it really is for everybody. And why? It's because estate planning doesn't just deal with what happens when you die. Estate planning helps with living. It's about living. Estate planning puts the control back in your hands about what happens if you can't make decisions for yourself. What happens if you do have kids? Who's taking care of the kids? It helps protect your dignity. It helps protect your people, especially in our community when our people may not be our blood families. So whoever those people may be, and whether you're in the traditional relationship where there's just one partner, or you're in an atypical relationship where you have multiple partners, your estate plan can actually address those types of situations. So who really needs it? Well, if you're over the age of 18, you do. And you're like, an 18-year-old needs an estate plan? Yes. At a minimum, they need powers of attorney because the second you turn 18, mom or dad, whoever, you can't do anything for your 18-year-old. Your 18-year-old's a full-ass adult and they have to go make their own decisions. So an 18-year-old needs powers of attorney for finances and for healthcare at a minimum. So who else? Especially people in our community, for reasons that we're going to get into later, people who are unmarried, solo adults, because even if you don't have a plan, the state will have one for you and it might not be what you want. So estate planning really does 3 things and it helps you answer these 3 questions. What about me? What about my stuff? And what about my people? Your estate plan, the what about me part, we're going to talk a lot about that because your plan is tailored for you. So it's the what about me? If I lose capacity, who's going to take care of my stuff? And we're going to talk about the stuff too, because that's sort of the dying part. What about me? Who's going to actually take care of me if I can't do it myself? Who's going to take care of my money? Who's going to take care of my investments, my real estate, my business, if you have a business? And if you have a business, that's an even bigger conversation, especially if you work in a business where not everybody can actually do your business, whether you're a doctor, a lawyer, anybody where you would have to have a special license to run your business. This is what we're talking about. But it's also about healthcare. Who's going to make healthcare decisions for you? The what about my stuff? After you pass, where's it going to go? Where are your retirement accounts going to go? Your life insurance, the house, the car, the boats, right? Whatever you have. If you have a special collection, if you don't have a plan that identifies specifically where these things need to go, California will tell everybody where it goes. And it might not be where you want, especially if you're partnered and you're not married, because newsflash, your partner is a legal stranger to you. You might know everything about that person. You might have shared assets with that person. But as far as the law is concerned, you don't know each other. And that brings us to the what about my people? This is where you have the opportunity to protect your people, whether they're your partner, your spouse, your kids, your family, your friends, all of those people your estate plan can protect and provide for. A lot of people think that it's just a bunch of documents, and they're not wrong. It is. It's a lot of documents, but they're really important. And the core 4 documents that you're going to have in any estate plan or any estate plan that actually is doing something are these ones. They're things that everybody needs and not a lot of people have. So what is it? The 4 that you're going to see most traditionally in an estate plan are your will, your revocable living trust, financial power of attorney, and your healthcare power of attorney. We're going to go through what each of those things are so that you know what the heck this stuff is. So the will, and a lot of times you've probably heard about all of these documents before in some context or another, whether you've had personal experience with family members or friends, or you've seen it on TV or in the movies. Like you think about somebody dying and everybody gathers around the attorney's desk for the reading of the will. That's what this document is. The will, when you look at it all by itself, says, I'm me, these are my people, so my spouse, my kids. This is the stuff that I have, and this is who I want it to go to. And also, these are the people that I want to actually deal with it. So, whether it's my spouse or somebody else, these are the people that I want to make sure they're the ones giving all of my stuff to my people. What does this thing do, and where does this thing go? This is a very, very public document. Public in the sense of when you die and you only have a will, that goes to court. Probate is opened. The judge says, okay, well, you identified this person to serve as your executor. They have to go through a hearing to actually confirm that. They have to sometimes pay a bond, which can be expensive. And it takes a really, really long time, especially in California, to get through probate. What else is about it that's public? If you have kids, that's where a lot of attorneys are doing guardianship nominations. We don't do that here. It's also every asset that you have, every debt that you have is going to become public record. And you're like, oh, I did not know that. Well, that's what happens. Your executor is going to go and corral all your assets, get a list of all your debt. They're going to submit it to the court, and then they're going to figure out who gets it. So in our situation, the people that you're going to be giving your things to, if you don't identify it in your will, if you don't have one, first of all, the probate code will say who gets it. So let's just take me for an example. I'm not married. I have a kid. If I kick it and I don't have a plan, like literally nothing, probate says my daughter, who is 10, will receive everything. She is 10. She can't do anything with money. Add in, if I had real estate, a 10-year-old can't do anything with real estate. So what happens is the court will hold on to that money until what time the court says the kid can have it, which is generally 18. That's a horrific time for a child to have any access to significant amount of money. The other part of why this is such a problem document is that if that's the only tool that you're using for your estate plan, while it's better than nothing, again, it's still public. You're going to be sharing everything with everybody. So it exposes your beneficiaries and your other important people to potential prey. Like there are potential risks to being extorted, to being, taken advantage of, because they're going to know exactly how much money they're inheriting. And it's not just little estates, right? You think people who, well, I don't have a lot. A lot is relative. And there have been some really substantial estates that have had to go through probate because the person didn't plan. Some pretty notable ones, Aretha Franklin, and this is not California specific, but this is, it's a problem. Aretha Franklin had wills, and she had ones that were called holographic wills, which mean they were handwritten. And her family was in court for years battling over which one's the right one. But it's public because that's what has to happen. She died, with a will or purported wills. And it can get very, very messy and very, very public. So how do we avoid that? That's where your trust comes in. In addition to keeping you out of the probate court, your trust will provide lifetime planning. So what happens if you lose capacity? Not only will you have a power of attorney for your money and for your health care, your revocable living trust will identify successor trustees who are able to pick up the reins and continue to serve as trustees, making sure that you're taken care of, your spouse is taken care of, your kids are taken care of, your pets are taken care of. Like all of the things that you need to continue to run your life, even though you can't do it, your people can. So your trust, when you die, does a different thing. So your trustee or your executor is going to submit your will to court, but your will is going to be a very, very different type of will. All it will do is identify you, your spouse, if you have one. It won't even identify your children. It'll say, I have one child or I have 3 children. It'll identify who your executors are, and it'll tell the court, you don't need to do anything else with this because I have a trust and everything that I own should be in this trust. You don't have to administer everything. We'll take care of it privately. That's what your trust is. But it also allows for you to do planning for a whole lot of reasons. You can just say, all right, we're just going to give everything outright, which is fine if that plan works for what you want. But if you have kids, especially, you're able to put a lot of controls over how and when they have access to money. If you have a spouse, especially if you have a spouse that's not a US citizen, there's planning that you can do to allow your non-US citizen spouse to receive assets without having the negative tax consequences that they would if they were to just receive it outright. So there's a lot of planning and customizing that you can do inside that trust that you have literally no control over if you're incapacitated or dead. Your financial powers of attorney and your healthcare power of attorney, it's the money and your healthcare. So for your financial power of attorney, think of it this way, it's a big document and it's probably the most robust of all of the documents that you're going to sign, because whatever you can do as an individual, your power of attorney can also do. And there's some limited exceptions on things that they cannot do. But for the most part, anything that you can do as an individual human being, this person's going to be able to do on your behalf. We call it a financial power of attorney because it mostly affects the finances, but there are other things that it can help with: dealing with spouses, dealing with pets, dealing with your gym memberships or your subscriptions, which seem kind of silly, but this allows you to not have to go to court. And when I say you go to court, you're not going to be going to court because you're going to be laid up somewhere because you don't have capacity. So what happens, and these 2 documents in particular, the financial power of attorney and the healthcare powers of attorney, those things kick on, they turn on. They're not just working right now. They only turn on when you lose capacity. So if you lose capacity and you don't have these documents in place, your family, who you may not want involved in any of this, or your friends, or whomever, someone is going to go to the court, a la Britney Spears. Think of Britney Spears, and they're going to ask the judge to appoint them as a conservator of you over your money and over your body. You again have no control over this because you haven't done any planning. What does that matter? Aside from the fact that it's just dumb and it's expensive, it's also, just like your will, public. So the conservator has to report back to the court everything that they're doing for you on the finances and on the healthcare. It leaves a lot of room for dispute, and it's completely unnecessary to have to go through that route if you don't have these documents in place. The other thing is that it helps just keep things moving, right? You don't lose the time in waiting for court. You don't lose the money trying to get those things in place. You have the documents. Your people are ready to step in. One of the other things specifically about the healthcare, and we're going to get into that a little bit more, the only way that you can guide the conversation about the care that you want to receive while you're alive and your end of life care, the only way that you can document that and have something where somebody else can advocate on your behalf is through that document. So if you have strong opinions about literally anything as it relates to your healthcare, if you don't have that documented somewhere, it doesn't matter. And I can't think of anything worse than having an opinion about something, about how I want to be cared for, and my people, 1, not knowing it, 2, not having the power to advocate on my behalf, or worse, having somebody who went to the conservator route who doesn't agree with me, doesn't want to abide by what I would have wanted, and does something completely different. So these documents really can help protect you, and you can advocate when you're in a position where you can't do it for yourself. So why does it matter so much for us? This system was not built for us, and that should be no surprise. It wasn't built for women. It wasn't built for queers. It wasn't built for people of color. I don't need to say who it was built for, because it was built for literally everybody. It wasn't built for anybody else. So what does that mean? Just because it wasn't built for us doesn't mean that we can't use it, and doesn't mean that we can't tailor it to meet our needs. So the law defaults to a traditional nuclear family. So when, like I mentioned earlier, when you die, either without a plan or you only have a will, and your will really doesn't do anything. But we'll talk about it in the sense of, I don't have a plan at all. What happens? the default laws kick in. And the default laws are really complex, especially when you start getting into blended families. When you have, we'll just use blended families as an example. If you have a blended family, it's a nightmare to try to figure out who gets what portion. I think more importantly is that it excludes everybody except blood family, and it won't recognize the relationships that we have, leaving your people that in a vulnerable position. So we'll use again, use myself as an example. I die without a plan. My 10-year-old's going to get everything. We'll use somebody else as an example. We've got a partnered couple. They're not married. They've been together for 25 years. Partner one dies. Partner one has been estranged from family forever. Over 20 years, they've been estranged. Partner one has a mom that's still alive, has a dad that was predeceased, and has 2 kids. Who's going to get that? It's going to depend. But here's the thing is that because mom, actually, we'll take the kids out of this. Let's say his mom is going to be the one that's going to inherit everything. He didn't have a relationship with her for over 20 years. They didn't have a relationship with this person. And this person's going to have this windfall. They're going to be able to take everything. And everything's going to be taken to the exclusion of partner B, right? This person that they built this life with for 20 plus years, they're getting nothing unless they've done any other planning. But everything's going to go to this person who's been estranged. And that's one of the really ugly parts of estate planning is that a lot of people who think it doesn't apply to them, or it's really not going to matter because everything is going to go to my person. I can't say that they're going to be surprised because they're going to be dead, right? But you're going to leave a whole lot of people holding a bag that they didn't want to hold. And you're going to have people who maybe didn't want to or didn't deserve it, getting things that you never, ever in a million years would have wanted. So those default rules, we have to be really careful, especially if we don't fit into this traditional nuclear family. And given the current administration, while we still have gay marriage and it's still a right for us to marry whoever we want, I don't know that we can rely on that. So what do? We have to have backup plans and backup plans and backup plans. So in the unlikely or unfortunate event that our marriages are no longer recognized, we have to have default provisions in here that would allow that person to continue to act and inherit essentially the same way a spouse would. And that's, again, when you have a situation where, well, we're married now, and if I die, they're going to get everything anyway. Maybe not, especially if you don't pay attention to what's going on. And in queer estate planning, here are some common scenarios and how we make things just a little bit different and a little bit better. Why would you need to really consider estate planning if you're in this community? You're not married, but you want to make sure that your partner has the ability to make decisions for you or inherit from you. And that's exactly the scenario we're just talking about. Partner A and partner B, not married, been together forever. I want you to be able to do these things for me, but unless I have documentation that says you can, good luck. You want your best friend and not that estranged sibling to be the one making decisions about your health care. Again, you could be best friends forever. If that friend is not legally allowed to make those decisions, they have no stake in anything. If you own real estate, we could probably have an entire webinar talking just about the unique needs of people who own real estate with people who are not their spouses. If you own real estate with your partner and you're not married, if you don't have an agreement that outlines what you're doing with that property, I will see you when things go south, either because you want to sell it or you're breaking up, because it's ugly and you can avoid all of that stuff. If you have chosen family and you're estranged from your bio family, like this comes up all the time. Part of estate planning is protecting you from people that you don't want to be around. And then if you and your partner have kids, we'll talk about kids a little bit more later. And I know not everybody has them. It's not everybody's cup of tea. But they play a really important part in all of this, especially if you don't have kids, whether it's by choice or whatever. If you plan on gifting to children, we don't just say, okay, we're going to gift it to your 6 nieces and nephews and just it's a free for all as soon as they turn 18. No, we're not going to do that because you love those kids. You want to provide for those kids, and we're going to make sure that they're successful in that. So we talked about the core 4 documents. We're going to talk a little bit more about why these ones in particular are key for our community. So for the advanced healthcare directives, it's a non-negotiable. If your family of origin is not affirming to either your life, if they're not affirming to you, we're going to be having a conversation about whether or not these are people that you want to be advocating for you on behalf of you for your healthcare. And we get really, really specific about your care while you're alive and when you're in death. And how do we do that? One is that we specifically authorize your agent to seek out care from LGBTQ providers or LGBTQ affirming providers. So whether you're trans, you're non-binary, you're cis, it doesn't matter. Your agent is there to specifically seek out treatment that's going to align with your values. We go a step further, especially for our trans clients. If you are seeking or want to seek gender affirming care, that you continue to seek, that your agent can continue to seek gender affirming care for you while you're incapacitated. We can also customize that language to identify the pronouns that you want to use. If there have been some other, like, not cosmetic, is not aesthetic, is probably not the right word, but probably the best way to describe this is that this is probably great in the non-binary sense, is that if you do not align with traditional gender appearances, you can put language in here that says, don't allow me to look one way or another, is that I keep my appearance this way for this reason, and I want you to continue to keep my appearance this way for this reason. Family planning is also a special interest of mine too, because a lot of people are child-free by choice, and a lot of people have really strong opinions about abortion care. We spend, especially with my clients who have the ability to become pregnant, we spend a lot of time talking about that. We give you some draft language to look at about if you want to have care, if you're carrying a child, like what type of care you want to receive at what intervals. We get really specific about that. And you're probably wondering, how do I know who to name in these situations? Because you might be thinking about one person and then you're like, you know what, maybe not, maybe they're not that good. It's okay. We go through when we're meeting with you and we talk about all your people. We talk about your family and we talk about your chosen people. And we figure out who are going to be the best people to serve in these types of roles, whether it's healthcare or finance, or with the kids, because they don't all have to be the same person. They don't all have to serve in the same types of roles. And with that, the financial power of attorney, again, this is going to help keep your family out of court, and it ensures that someone's there to keep going if you can't. And again, we include that inclusive language that your agent is encouraged to continue working with LGBTQ providers and LGBTQ supporting providers with kids. Nomination of guardians, again, is super important. And it's not just naming a person. We go a couple steps further than that. We name short-term guardians. So if something happens, like for me, my kids' guardians are not in this state. It's going to take them at least a day to get here. So who's going to take my kid in the interim? We have short-term guardians to allow for stuff like that, where you have a longer-term guardian who needs to get here from somewhere else. That way your kid doesn't end up in foster care, because babysitter gets a knock on the door, something happens to you, they're looking for what's the best interest of the child and necessary and convenient. What's necessary and convenient is getting that kid in foster care so that they're with somebody that's definitely not where you want them to be, but that's what the police officer is going to do. One of the other things that we talk about a lot, especially in parentage, is that especially if you're not the biological parent of your children, making sure that you have taken the necessary steps to acknowledge and recognize those relationships, because just having a name on a birth certificate may not be enough. Having to actually go through that process of either a second parent adoption or a confirmation adoption, if that's something that you have not already done, is a really important part of making sure that your whole plan is intact. And then we keep it private. Like I mentioned earlier, we don't name them in the will. We do it in a separate document. But this document also is more like, the way that I describe it is, it's like it's the playbook that you wish that you had when this baby was born. You get to tell your guardians, if I were here doing this thing, these are the things that I would want my child exposed to or not exposed to. And this is a totally customizable document. It's just evolved over time. But it's a really great opportunity for you to tell your people, this is what I want. Like, do the best you can, but like try to incorporate what I would have done with my kid if I was able to do this myself. And then you is like, but I'm not a document. You're right, but you're all over these documents. Your story is all over these documents. And when I said that this estate planning was not made for us, it wasn't. It uses very not specific language as far as identifying people. So it's he's and hims and hers, and that's it. But that's not how we do things here, because if you use any other pronoun, we will make sure that your documents are customized to reflect who you are. So you don't have to worry about opening up a document and one, being dead named, or two, seeing language that doesn't align with who you are. So we really make sure, and it might not even be you. Maybe you have a friend or a family member or someone else in your circle that uses something other than he, him, or she, her pronouns. Like, this is an opportunity for us. It's like, if you tell us, we will make sure that they are also incorporated appropriately. All right, some other fun things about why our community is unique in the estate planning space. Real estate is a big one. I work with a lot of clients who are not married buying real estate together. What happens if you're not on title? Who gets it? Newsflash, if you're not married, it's not you. How do you get out of it, especially if you aren't married? Again, newsflash, you don't get to go to family law court. You just get to sue each other and go to civil court to get out of it. It's ugly, it's messy, it's expensive. We talk about all these things to make sure that you understand the risks and that if you need to be connected with other people, we can help connect you with those people. I do or I don't. I don't care if you're married. Don't care. Don't care if you're planning on getting married. Don't. It doesn't matter. Your choice on how you want to spend your life and who you want to spend it with is entirely up to you. But marriage changes everything. And the planning for the what ifs, when we talked about whether or not our marriages would continue to be valid, is something that we're planning for the contingency of the what if it's not, right? And this is, before that went into place with 2015, we had to do creative planning to suit, pseudo spouses so that you had the authority to make decisions and actually inherit. What happens if you're in a polyamorous relationship? You better have a plan, because in no state are you allowed to be married to more than one person. So if you are in that situation where you have a poly relationship and you want to make provisions for other people, or you want other people to be able to make decisions for you, you have to have a plan. And then the fam, we talked about this already. They're legal strangers to you. I said, even though, like, it's the farthest thing from the truth. We know that they're not actual strangers. They know you better than most people. As far as the law is concerned, they're strangers. So if you want to provide for those people, you have to have a plan. Okay, and with that, getting started with estate planning. Well, first of all, you made a good step by coming here to learn a little bit more about it. It's not that scary. I know it sounds scary. We're all going to die. Like, that's just a given. If we knew when and we knew how, I guarantee that none of us would be doing what we are doing right now. But what we can do is we're planning for living, right? We are going to live. And in order for us to live, it's really nice if we have a plan so that we can continue living without worrying about what's going to happen. We don't know what's going to happen, but knowing that you have a plan in place, that if you can't make those decisions, someone else can help make those for you because you've given them the playbook on what you want and how you want it. And then making sure that you're protecting your people. So how do we work at Your Home Legal? Your estate plan process is generally over 3 or 4 meetings. I learn stuff about you. You learn stuff about what we're doing, and then we wrap everything up with a funding meeting. So your first meeting is a learning meeting for me. I ask a lot of questions about who you are, what you have, all about your people, what your wishes are. I then take all that information and turn it into a plan. I give you the plan. You get to take a look at it. And then we go for your next learning meeting. And this is a learning meeting for you where I walk you through all these documents so that you understand this is what your will is. This is how it works. This is what your trust is. This is how it works. And then all of the other documents that are in there. We're confirming your choices. We're confirming your people. And then once you've approved everything, then you sign it. Then we meet one more time for your funding meeting. Your funding meeting is, congratulations, you just did this really hard thing. You have a tiny bit more homework to do. Because part of your process is going through and looking at all the stuff you have and making sure that all of the accounts are updated, the beneficiaries are updated. We're also really collaborative. I stay in my lane, real estate and estate planning. I stay over here. But our lives are not like that. If you have a financial advisor, I want to know who that is. You have a CPA, want to know who that is. Family law attorney, all of the people that are helping you live your life on the professional side, I want to know them, because we all need to know what we're doing with each other so that my plan works with your financial advisor's plan, which works with your CPA's plan. It's really helpful when your team actually is all together and they know what's going on, because you don't want to be doing one thing over here and over here we're doing something completely different and it's going to mess up this plan. So I really like to collaborate with your other professionals, especially on the funding meeting side, inviting your financial advisor to that meeting so that they understand what's going on and they can actually help you with that funding part. We work virtually. I work with clients all over the state of California. We meet over Zoom, and you don't have to go anywhere to sign your documents. Everything can be done at home. You can be in your pajamas for all I care. You'll meet with a remote online notary, which is wild. I love this. But you don't have to go anywhere, and it's great. The process is usually between 2 months, about 2 months, depending on how quickly you turn documents back in. And then we have some tips for you. So whether you work with us or you work with another attorney, work with somebody who aligns with your values. If you can't have a conversation with this attorney about who you are, what you stand for, and what they stand for, and if those things don't align, don't work with them. You don't have to. Do they work with your team? If your attorney's not asking you for your team, it's not going to be good, because if you need referrals, they need to know who to refer you to. And if they don't even care about the other people on your team, they're probably not going to be able to give you good referrals. And then do they check in on you after you're done? This is not a one and done type of situation, because life is always changing. People are growing up, people are dying, people are getting married, people are getting divorced, buying real estate, all of those big life events are reasons for us to just check in to make sure, hey, do we need to change anything? Right? Did the person that you named on your advanced healthcare directive, are they still good in that role? Or what about the guardians of your kids? Did someone have a red hat moment where they are no longer who you thought they were, and definitely not people that you want raising those kids? Right? So are they checking in with you? Do they have a plan to check in with you? Okay, with that, I'm going to take a minute and say thank you. All of my contact information is on the screen. The QR code on the right will take you to our scheduling page for your free 20-minute consultation, where we'll talk more about estate planning, what it looks like for you, if we're a good fit. As an aside, all of my business is done on a flat fee basis. So no hourly billing. You're going to know right up front how much things are going to cost. And how much it's going to cost is going to depend on what you have and whether or not this is more complex and it's going to need extra things. But everything's flat fee.